you also have, a strong presumption of diversion, of trying to deal with matters in any other way other than, taking them, all the way through the criminal justice system, right? And so the way diversion works, I mean, there's many different forms of diversion in Canada. There's formal diversion, informal diversion. There are sentencing circles. There are, other approaches, mental health diversion, drug courts. And what those processes, all of them involve, is saying, okay, we're not going to go down the regular stream, which is like, did you do it or did you not do it? Can we prove it? Can we not? If we can prove that you did it, here's a list of consequences and we're going to, sentence you to jail or some other sentence. For diversion that we're not so concerned with whether you've done it. Like, certainly a lot of formal diversion, you're required to accept responsibility. That's a prerequisite that you did do it. But they're often geared more towards repairing some of the harm that was done by the behavior, rather than exacting a particular punishment on the young person. So the structure of it is often, for formal diversion, or community-based diversion, apology letters, community service. Sentencing circles can be about that as well. Like, they have you meet with, or you sit in a circle, you meet with, potentially have participation of the victims in this situation, other community members, other support people, and you're confronting the harm that you've done. You're accepting responsibility, and you're strategizing ways to repair the harm. Could be restitution, right? Maybe pay the money back, or try to pay restitution through community service, apology, accepting responsibility. All ways to try to rectify the system without in a way that's potentially less traumatizing. Obviously, it can still be, very stressful to sit in a situation like that, to confront, harm potentially that you've done, to accept responsibility. But I think the idea is, and I think there's good evidence for that it would be less traumatizing, less harmful for the young person than, for example, custody, or even, a sentence that doesn't involve jail, but, still really restricts the liberty of the young person out of custody. So those are some of the procedural accommodations. Certainly, there's a very strong presumption, or very strong section in the Youth Criminal Justice Act that make sure that jail custody is not used as a means for other social measures, for assisting with mental health or housing or anything like that. So that can be, because I think there historically were situations where maybe a young person was charged with something, but there wasn't a particularly strong plan for them to get out because they had mental health issues, or they were experiencing financial instability, and maybe that was the source of some of their offending behavior. And there just weren't the hospital resources or the housing resources, or counseling resources, other resources to help the young people. And custody facilities were used as social measures of last resort, and that is forbidden within the Youth Criminal Justice Act. And so, again, trying to really strengthen the divide between, when the criminal justice system is the system to deal with the issue, and when we have to look to other social departments that are the government's responsibility to address this issue. And so, when those institutions aren't particularly strong or underfunded, that can be a weakness of the system. Or if you're looking to replicate the successes in the Canadian system, if you write in those kind of very strict limitations on the use of the criminal justice system, but you don't have the other departments, the other service providers funded and working, then that can be a potential pitfall that makes those procedural safeguards not as effective. So it is designed to be something where the community is involved, families are involved, other social services are involved. It doesn't happen in all cases. It's not appropriate in all cases. Many times families don't want to participate, victims don't want to participate. They're certainly given the opportunity. There's lots of procedural rights and protections for victims' participation, for and as I said, the preamble really is talking about addressing the root causes, and that involves the family or the guardians or whoever's taking care of the young people. But depending on the structure of the program or what the offense is, it's not appropriate in all situations. It's not allowed in all situations. There's certainly some exciting pilots that are pushing the boundaries of what kind of offenses can you use this type of restorative approach. And there's a really strong presumption of using a restorative approach when we're talking about Indigenous young Canadians.